Everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are lucky to have Carolyn Conron to talk about criminal procedures, which is the second part of her presentation about criminal legislations and issues in Canada. Thank you so much for being here with us, Carolyn.
Yes, thanks for having me, Hetham. It's a pleasure to be here again, and thanks to everyone for joining us again on the Rights and Responsibilities Awareness Initiative channel. In our last session, of course, as you mentioned, we talked about individual rights when dealing with the police, including the right to remain silent, to not participate in an investigation, and then we talked about as well grounds that police have to lay charges. If charges are laid and you're a victim or a witness or an accused, that's what we're going to be dealing with in this session. So for someone who is a victim or a witness of a crime and charges are laid, there's different expectations than for someone who is an accused person. So if you're a victim or a witness, you could expect to be updated by the investigating officer, or there's also a victim witness assistance program known as VWAP, and they act as a liaison to let the victims or witnesses know about any of the conditions of release that an accused is placed on, any updates for the court dates as the matter winds through the system, and then ultimately as the matter proceeds through, if the Crown requires any input from a witness or a victim about a proposed resolution, the Crown can seek input from them. If the matter proceeds to trial, the individual's going to get a subpoena to attend court, which is a legal document that compels the person to attend. In advance of the trial, the person would get their statement to review, just to make sure their memory is refreshed in advance of the trial. But when they're testifying, they don't have that in front of them unless they specifically, the judge allows it for the purposes of refreshing their memory. And then attendance to the court for that person could be in person or sometimes closed circuit television, CCTV, sometimes remotely by Zoom. So there's different ways that someone could attend court. If they ignore a subpoena, different things can happen depending on the particular case. So sometimes the judge will issue a material witness warrant. Sometimes the Crown will make the executive decision to say, this person's not wanting to participate in the trial. There's no evidence to provide on their behalf, and so charges have to be dismissed. But it will just depend on the facts of a particular case. So that's if you're a victim or a witness. And victim is defined in the criminal code as anyone who's alleged to be a victim as well. So sometimes there's another term called a complainant, and usually that term is going to refer to someone who initiates the complaint. So sometimes the victim is the one who initiates the complaint, but not always. So those are some terms that you might hear from one side of things. If charges are laid and you're the accused, then the process is much more involved. And as we discussed in our last session, the presumption of innocence is present for all people accused of a crime. And the presumption is for them to be released at the earliest opportunity and on the least onerous terms. So any charges that are laid, that the police have reasonable and probable grounds to believe the offenses have occurred, they're listed on what's called an information. And that information is sworn by an officer, and the document goes before the court as the matter proceeds through its various stages. So if further charges are laid, they can appear on a separate information. And so sometimes people have multiple informations before the court. And in different circumstances, there can be joinder or severance applications to either bring the charges together or separate them. Anyone that is charged with a crime is presumed innocent, and this is fundamental. It's a fundamental tenet of our justice system. The presumption does not change throughout the process and does not change unless the Crown satisfies the court that the accused is guilty beyond a reasonable doubt. And so that's the final stage of the process, but it does take longer than you would expect to get there. I can tell you, everyone has the right to be tried within a reasonable amount of time pursuant to Section 11B of the Canadian Charter of Rights and Freedoms, which in a case called Regina and Jordan, the Supreme Court of Canada set these presumptive ceilings. So in terms of what is a reasonable amount of time, that could be 18 months or it could be 30 months. And so what they do in that assessment is they'll say, well, how long has been the total delay? Has there been any defense delay? Subtract that. And then what's the net delay? You know, there's also, they take into account any exceptional circumstances or sometimes the complexity of the case. But to get to trial, it can take quite a while. So, you know, there are these presumptive ceilings and everyone has the right to trial within a reasonable amount of time. But that reasonable amount of time still seems like a long time if you're someone who's facing charges. In terms of the initial attendance to court, the police do have different options when it comes to compelling an accused person to attend court. So they can issue a summons, an appearance notice, which are sort of just like tickets, almost looking like that. They can release a person on a promise to appear with an officer in charge undertaking, which is, so an undertaking is a formal promise that someone would make, and it would have specific conditions on it. So for example, don't talk to this person, don't go near their residence, employment, or education, don't be within 25 meters of their person, no weapons, things like that. And that's an undertaking to the police. So it's a promise that someone would make to follow those conditions as terms of their release from the police station. And then they also promise to appear in court on a separate document. But if the person's not released by the police, right at the start of things, the individual is going to be traversed to the court. And at the court, there's a Crown who's a bail vetter, and they look at the allegations, the individual's criminal record, if they have one, and then they'll take a position on the Crown's recommendation of the release. So the Crown can recommend or consent to a release on various conditions, sometimes with surety, sometimes without, or they can seek the detention of an individual who's charged with a crime. So if an individual is compelled to attend court on an appearance notice with the fingerprinting date, there's a fingerprinting date under the Identification of Criminals Act where someone has to attend for fingerprints and photographs. This is mandatory. So failure to appear for that could lead to a further charge if the individual does not attend. And any conditions of an undertaking or a release from the court are mandatory. So an individual who's alleged to have breached these conditions can be charged with a separate offense, and that has different elements of the offense from the initial charge. So even if the person is found not guilty of their initial charge, they could still be found guilty of the breach of the conditions that were imposed as a result. So that's something to be mindful of. And if someone is facing criminal charges and they have conditions, make sure to follow those. It's very important. If the Crown is seeking detention, there is a hearing that's held to determine whether the individual can be released or not in advance of trial. So it's called a show cause hearing, because either the Crown has to show cause for the person's detention or they have to show cause for their release. But every individual who's before the court is presumed innocent. And so the hearing is to determine whether or not they could be released to face the charges. And then there's 3 different grounds that a justice would consider when determining pretrial release or detention. So they're under Section 515.10 of the Criminal Code. And there's 3 grounds. So the primary grounds are whether detention is necessary to ensure the accused's attendance in court. So if the court releases them, will they show up? Will they required to do so? The secondary grounds are whether detention is necessary for the protection or safety of the public, having regard to all the circumstances, including whether there's a substantial likelihood that the person would commit further offenses or interfere with the administration of justice. So on that ground, the court considers, would this person commit further offenses if they were out that would put the public at risk, or will this person breach again? So they'll consider, is there a history of breaching on their record, not only charges that they're facing, outstanding charges, because for those, of course, they're presumed innocent, but is there a history of breaching? Is there a history of committing further offenses, particularly while on bail? And then the tertiary grounds are whether the public would lose confidence in the administration of justice if the accused person was released. So in terms of that, they look at the public as a reasonable and informed member of the public, apprised of the full circumstances, including any bail plan that's put before the court. So the bail plan will be the particular conditions that are proposed that the accused person would follow, and as well the principles of bail, the presumption of innocence, the importance of liberty in a free and democratic society. All of those things are factored into the justice decision on whether to release. But the presumption is release, and detention is warranted only in a narrow set of circumstances. And of course, we're just discussing the broad strokes here. So any of the evidence that's called on the bail hearing, submissions on the law, you're going to want to have a lawyer there to make those submissions, to help you to prepare a bail plan, and to take control of this aspect of the proceedings, because it is very important. And people who are detained in custody from the start are more likely to plead guilty, and it's harder for them to mount a defense. So it is very important to have this initial stage addressed in a proper way before moving on to the next steps. So a judge hears the evidence called at the bail hearing, and they'll determine on a balance of probabilities, can this accused be released, or is their detention necessary? And that's sort of the first stage of what happens after someone is charged. The release is determined, and then the conditions of the release, if any. And any conditions of the releases are mandatory. So again, if you're someone who's accused with a crime, make sure you follow these conditions, because if you don't, it could be charged with a further offense under Section 145 of the Criminal Code and be facing additional charges. It could be back in custody, and then sometimes you have to show cause for your release instead of the Crown showing cause for your detention. It's a reverse onus. So assuming someone is released, and even if they're detained, following that, there's a series of court appearances. And these are check-in dates for the court, for a judicial officer to monitor what work is happening in between those dates. So the dates kind of are check-in dates to make sure that the lawyers are doing the work in between. So it starts off with the Crown providing disclosure. Right? And as I mentioned before, the process can take longer than you might expect. But at the first appearance, the process is confirmed, and the Justice of the Peace will ask the accused person, do they want the charges read to them, or do they want the reading of the charges waived? There's also a language right. So as between English and French, the accused will select their language preference. So on a first appearance, the judge will say, do you waive reading of the charges? Do you want to elect proceedings in English? And if not, then they will read out the charges to someone, because everyone has to know what charges they're facing. And then you have the option as an accused person between the two official languages of our country. And other languages, you would get an interpreter. So, well, even with French, typically there is an interpreter, primarily in London, Ontario, where I practice, it's English. So even if someone elects in French, it would be rare to have the proceedings without a French interpreter. But the court can order interpreters for any other languages. And then usually the language selection is English, and then that's they'll have an interpreter to translate English to any other language. Again, at the first appearance, the Crown will often be in a position to make an election on the information. So for some offenses in the criminal code, the Crown has the option of electing by summary conviction or by indictment. And then other offenses are in the criminal code are straight summary, others are straight indictable. And summary matters have lower penalties set out as with their maximum possible sentence in the criminal code. Indictable matters have maximum penalties that are higher. And as well, in terms of other distinctions between summary and indictable matters, for summary matters, the accused will only be able to have a trial in the Ontario Court of Justice. And for indictable matters, the accused has an election to make, so they can decide to have a trial in the Superior Court with a judge and jury, or a Superior Court judge sitting alone. Or they can also elect to be tried in the Ontario Court of Justice. So the decision on the defense election is a strategic one. And then obviously best to discuss that with your legal counsel, depending on the particular circumstances of each individual case. But if the matter is one that carries a maximum sentence of 14 years or more, the accused is also entitled to have a preliminary hearing where there's an opportunity to test the evidence with witnesses under oath. And then at the preliminary hearing, if there is some evidence upon which a reasonable and properly instructed jury could find guilt, the accused would be committed to stand trial on that charge or other charges that are disclosed in the evidence. That's called the preliminary hearing. So it's sort of a screening function. It can help weed out weak charges. If there's no evidence, then the charge is dismissed and it doesn't go any further than that. But if there is some evidence, it also helps to serve a discovery function to help to explore the evidence a little bit with witnesses under oath at an early stage. And when the Crown elects and you've got what your charges are, usually so from the first appearance, there's an adjournment. So the matter will be put over for some time to another date, which is called an adjournment. And usually within that first time frame, the Crown will provide disclosure, and that allows an accused to make full answer in defense to the charge. So this would typically include any witness statements that are taken, any police statements or notes. If there's a cell phone analysis that's taken as part of the investigation, screenshots, photos or videos. And sometimes depending on the type of case, there's expert reports. So it could include something like a firearms analysis or a fire examiner report. Sometimes they'll have in drug trafficking cases an expert report to say, was this drug possessed for the purpose of trafficking or just simple possession? But any piece of evidence that the Crown intends to rely on at trial to prove the charges has to be disclosed to the accused to make full answer in defense. And then it's always the Crown's obligation to prove the elements of the offense beyond a reasonable doubt. So where there's no reasonable prospect of conviction, and if there's no public interest in pursuing a charge, the Crown can withdraw it in those circumstances. So the Crown's obligation is to represent the public interest. So the Crown is not a lawyer for the police. They're not a lawyer for the victims or any witness, and certainly not for the accused. But the role of Crown counsel is not to obtain a conviction. It's to put before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime. And so sometimes, victims or witnesses will come forward and they'll say, I don't want these charges to go forward. I don't think that anyone should be prosecuted for this. I don't want them to go to jail. And the Crown gets to make an independent determination of whether there's a reasonable prospect of conviction and whether this is in the public interest. And those terms are in the Crown policy manual, and they have specific definitions. So particularly in domestic violence cases, the public interest is served not from what the victim wants necessarily, but more from a public standpoint of creating a society where domestic violence offenses are prosecuted, even if the domestic complainant doesn't want this to go ahead. So the Crown has to provide disclosure. They have to consider the reasonable prospect of conviction, the public interest, and then once the disclosure is complete and the defenses have an opportunity to review that, to review it with their client, and then after that, there's a meeting with the Crown. So I've had disclosure take a long time. Sometimes it takes upwards of 6 months to receive in this jurisdiction in London, but other jurisdictions it's much faster, and I'm sure in some other jurisdictions it's slower, but it can take a long time to get that disclosure, which is crucial to being able to make full answer and defense. Without that, it's hard to know what next steps to take, because there could be important pieces of information that are relevant to the accused defense that are in there, and it's important to have that. But once counsel and the accused have had a chance to receive that and review it, there's a meeting with the Crown, sometimes called a Crown pretrial, and counsel will discuss the issues for trial or any potential resolution. So if there's a resolution that can be reached, then the counsel would go back to their client and say, you know, here's a potential resolution. What are your instructions on that? And then the client provides their instructions, because it's always up to the client whether or not to go in a particular direction with the legal matter. You know, and people can self-represent as well. So if someone doesn't have a lawyer that's representing them, they can also meet with the Crown on their own and suggest a resolution or discuss trial issues. But it's much harder for a self-represented person to go through the system, first of all, because they're not familiar with the procedures. And if they're not familiar with the law, they may be missing out on certain issues that arise in the disclosure. So for example, if there's charter issues, so last time we talked about the grounds that someone has to arrest. If there are no grounds to arrest or to detain someone, then that's an arbitrary detention. And that could lead to a finding under Section 9 of the Charter that someone was arbitrarily detained, right? Or if there's an unreasonable search and seizure, then you could make an application under Section 8 of the Charter, because everyone has the right to be secure against unreasonable search and seizure. The same thing with Section 10 and rights to counsel, or Section 11B and the right to be tried within a reasonable amount of time. So there are charter issues that can come up, and if you're not familiar with what those are, then it can be much harder to spot those issues and to defend the case, and to advocate for yourself in that way. Because in order to assert these charter issues and to seek a remedy, they have to be usually materials filed and an argument that's made before the judge. Although a judge does have an independent obligation to address those, but typically those charter issues are going to be identified in advance, raised, and there's an application and a factum that's prepared to argue those issues and to decide how they're going to be resolved. Because if a judge finds that someone's charter rights have been breached, then the next step of the analysis is going to be, well, what's the remedy? And under Section 24(1) of the Charter, charges could be stayed, which means that they don't proceed any farther. Or under Section 24(2), there can also be the exclusion of evidence. So if it's a drug case, for example, and some drugs are seized, and the judge makes a finding that there was an unreasonable search and seizure in a Section 8 breach, the next stage of the analysis is, will the evidence be excluded? And that's an analysis under Section 24(2) of the Charter, taking into account the case law and the legal principles there. So those issues would be discussed at the Crown pretrial, at the judicial pretrial, because it affects the court time that's required, and it affects sometimes the scheduling of it. So if there's a charter application, will that be heard in advance? If there's a voluntariness application, for example, if the person didn't have their rights to counsel or caution read to them, and they provide an extensive statement, sometimes it's helpful to have those applications in advance of the trial so that everyone can know what evidence would or would not be admissible. And sometimes if the evidence is not admissible at the trial, there's no need for the trial. If the drugs are excluded, if there's guns and it's excluded, then there's no evidence to prove the charges. So those issues are identified early on at a Crown pretrial, at a judicial pretrial. And then once the judge gives the go-ahead to say, yep, you're good to go, these are the issues, here's the time estimate. And then after those procedural hurdles, then the trial date is scheduled. So from the time that a matter gets onto the date setting list, typically it's months away from when the trial actually occurs. And the bail conditions that someone is on from the very start will still remain in force until the trial is completed, which includes sentencing if the accused is found guilty. So people can apply to vary their bail conditions at various points. So sometimes there'll be curfew imposed and someone wants to change that. So there is a form to do that. And if the Crown doesn't agree, an accused person can always initiate court proceedings to do a bail review and have a judge look at those conditions and determine if they're reasonable and they're the least onerous necessary in the circumstances. So once the trial date's set, then the preparation for that is going to continue. And at the trial, the Crown will bear the burden of proof to prove the elements of the offense of any charges beyond a reasonable doubt. And so beyond a reasonable doubt is a high standard. It is a test, it's a safeguard of our liberties. And probably guilty or likely guilty is not enough, although it is impossible to prove something to an absolute certainty. So it's not as high as that, but it's quite high. The trier of fact must be sure that the accused committed the offense, and that's hearing all the evidence. So the Crown has to call evidence, so they can do that through witnesses, and witnesses are sworn or affirmed with a solemn promise to tell the truth, and then they provide their evidence under oath, and then that's tested by cross-examination. So sometimes there's not any corroboration or confirmation of the evidence. It's just sworn testimony from, one or maybe just one individual who says this is what happened. And then the other side gets to cross-examine them. So this is your evidence under oath. Well, let me ask you some other questions. What about this? And that's the testing of the evidence that happens under cross-examination. So a judge will hear the evidence, they hear the cross-examination, and then they're going to make an assessment of that. So they'll assess this person's credibility. So are they telling the truth? And they'll assess their reliability. So their capacity to perceive and recall events. Reliability, I always like to refer to the My Cousin Vinny scene with the woman who doesn't have her glasses on when she makes her observations. So she's a credible witness in that she seems to be telling the truth about her observations, but she's not reliable because the thing that she's telling the truth about, she didn't really accurately see. So the judge hears all of the evidence, and then they'll determine what evidence they accept. They can accept some, none, or all of what a witness is saying. And each witness that the Crown is going to call, the defense has an opportunity to cross-examine those witnesses. So the Crown has to call all of its evidence. That gets tested by cross-examination. Each witness gets tested by cross-examination. And then at the end of that, if there's any exhibits to be filed or documentary evidence, sometimes those can go in without calling witnesses, but at the end of the Crown's case, they'll say, yes, that's the evidence for the Crown. And then the defense has an option to call evidence. Defense doesn't have to call any evidence, and that's because it is the Crown's obligation to prove the charges. It's not up to the defense to prove anything, but if the defense wants to, they can also call evidence, which could include any witnesses, or they can testify themselves as to the events. Sometimes they are the only other witness other than the complainant. So they would get up and they would say, no, this is what happened, and provide their version of events. And then the Crown gets to cross-examine them to test that evidence. And so the evidence is called and it's tested. And then the judge, after hearing all the evidence, they weigh it, and then they'll assess the credibility and the reliability. And then they'll make a determination on the issues based on the evidence that they do accept, applied to the legal standard. Has the Crown proven the charges beyond a reasonable doubt? If the accused does testify, if the judge believes them, then they're entitled to an acquittal. If they don't fully believe them, but it raises a reasonable doubt, again, the accused is entitled to an acquittal. And even if the judge rejects an accused's evidence entirely, they still have to consider, on the basis of the evidence that they do accept from the Crown, has the Crown proven the charges beyond a reasonable doubt? And that's, again, hearkening back to the presumption of innocence and the Crown's burden of proof to prove the charges beyond a reasonable doubt. So after hearing all the evidence, each lawyer will make submissions, and that's their pitch on, here's what evidence you should accept and why, and here's why. It either, from the Crown side, will say this does establish the elements of the offense beyond a reasonable doubt, or the defense will say it doesn't, right? Here's where the evidence has failed and it's not sufficient to form a finding of guilt beyond a reasonable doubt. And then the judge sometimes is in a position to make the decision that day, or often they want to adjourn the matter or put it over to another date to consider the evidence and render their decision. And so when they are in a position to make the decision, they will read out the evidence. They'll say why they accepted it or didn't accept it, and then make their findings of either not guilty or guilty. If the judge finds someone not guilty of the offenses, then that's it, then they're done. And then the bail conditions are done, and then they just get to walk away. What a relief for that person. If not, then if they're found guilty, then the matter proceeds to sentencing. So there can be different positions on sentencing. So the Crown and defense don't always agree on an appropriate sentence. And then that's another matter that the judge has to decide. For someone who's a victim or a witness, typically just victims, but sometimes there's community impact statements, but victims can provide a victim impact statement talking about the impact of the crime on them, including any emotional or financial consequences that they've endured, things like that. And then the judge will take that into account along with any materials provided by the defense. That often will include a pre-sentence report that's prepared by probation, going into the person's background and circumstances, or any other supporting documents like character reference letters or confirmation of counseling. Immigration consequences potentially can have an impact on sentencing, and any number of cases that the counsel are submitting that are relevant and impact on the appropriate sentence. So the sentence has to be proportional to the gravity of the offense and the degree of responsibility of the offender, and take into account a number of sentencing principles, including denunciation, deterrence, promoting a sense of responsibility in the offender, reparations for harm done, separation from society where necessary, and rehabilitation. So the judge will consider all of those factors and then increasing the sentence for any aggravating factors or decreasing it for any mitigating factors, and then ultimately arriving at a just sentence that takes into account the principles of sentencing and is proportional. So that's then once the sentence is imposed, it could be jail, could be a fine, it could be probation. Typically there's two forms of probation. So suspended sentence, which is a criminal conviction where the judge suspends the passing of sentence and places the person on a period of probation, or conditional discharge, which is a finding of guilt, but not a criminal conviction. And they're on probation for a period not exceeding 3 years. Also, there's an absolute discharge, which is a finding of guilt, but no probation conditions. And those are all some of the options that can come from sentencing. So once the person is sentenced and they're on their way, that's where my job typically ends. Other lawyers have jobs dealing with appeals of the finding, of the conviction, appeal of the sentence. Other lawyers deal in prison and parole law, so assisting a person to deal with the parole board or deal with Corrections Canada. But my job as a trial lawyer is strictly focused on trial advocacy, and so that's where my role typically ends. But that's an overview of the process from the charge to the release, the bail conditions or conditions of release, a little bit about the adjournments throughout the court for disclosure, instructions, Crown pretrial, judicial pretrial, date setting, having the trial, and then there's the findings, and then if necessary, a sentencing date. But yeah, do you have any questions there?
So much this informative presentation. Actually, if you could please clarify more about reasonable grounds. So when you say reasonable, what do you mean by reasonable? And is there any sort of standard for something to be considered reasonable?
Yes. So a reasonable doubt is a doubt based on reason. It's not frivolous. It's not based on sympathy or prejudice. It's based on the evidence or an absence of evidence. And I mean, doubt is, are you sure? Are you not sure? Did this happen? Did it not happen? There's all sorts of case law and suggested wording in terms of reasonable doubt. But essentially it arises from the evidence or from the lack of evidence.
Mm-hmm.
Are you sure or are you not sure?
Yep. So
is there an explanation? So for example, it could be a text message conversation between two people. One person says, these messages are from this person, and they get charged with a breach. But at trial, the number is not associated to that person. It's just a text number. And so the Crown can't prove in that case that it was the accused that was breaching rather than any other person who was texting that. Right. So it might seem like the accused was the one who was sending those messages, but can you be sure, or do you have a reasonable doubt?
So yeah, that conviction need to be 100%.
So not 100%, because it's impossible to prove something to an absolute certainty, but probably guilty or likely guilty is not enough.
Okay, so can you provide a little bit more about disclosure? What's
that?
What is the disclosure? What the concept of disclosure?
Yeah, so disclosure is the evidence, or I guess the statements the Crown would rely on to prove the charges. So if it's a witness that says this is what happened on this day, it would be their statement. So sometimes the statement is just typed up in the police computer, Sometimes it's audio recorded and sometimes it's video recorded. And so, if someone is saying this person assaulted me, well, what are the details they provide, right? How did this happen? And what did they say occurred to establish this assault? And then that way, once you as an accused person, you can see that and you can say, well, that's not possible because how they described it, the layout of the house isn't like that, or, um, you know, different things, right? So once you know the actual specifics of the allegations, the particulars, then you can be in a position to defend against them. And so that is all coming through disclosure.
Okay, so last but not least, can you tell us a little bit about the duty counsel?
Yeah, so duty counsel is it's a publicly funded, kind of like the public defender model. So they are in court for people who are unrepresented or who can't afford a lawyer, and they assist people through the process. So if someone doesn't have a lawyer and they go to the courthouse for their first appearance, or even if they're appearing by Zoom, they can connect with duty counsel, and that is a free service, a public service to assist people with understanding the process. So they can talk to this person, say, here's where I'm at. This is my first appearance. I have no idea what's going on. And the duty counsel can take a look at their disclosure and say, here's your options. And then assist with the adjournment to get another court date so that they can explore those options. So whether that's retaining counsel or going to speak with the Crown on their own. I think sometimes duty counsel will go with the person to the resolution meeting or Crown pretrial in order to help them to advocate. And so they assist people who don't have lawyers, or sometimes whose lawyers aren't available. So the duty counsel can run bail hearings for individuals as well.
Thank you so much. Well, at the end of this presentation, I'd like to express my thanks to you, Carolyn, for all of this kind effort and for your support to Rights and Responsibilities Awareness Initiative. Thank you so much. And we are looking forward to have you at another sessions with us.
Thanks so much, Heather. It's so nice to be here.
Thank you so much. And for everyone here, stay well, stay safe, stay out of trouble. And we are looking forward to welcome you at another session with Rights and Responsibilities Awareness Initiative.